Listen up, folks. Are you concerned about your privacy now? Just wait until you die. If you don't have a trust that all of your assets are going to be listed out there for everybody to see, I didn't know that. Everything. Today's episode is going to explain what that's all about. You really might want to listen. Welcome to the Cedar Harvest Show, where financial education meets real-life choices that impact your family, your future, and your legacy. I'm your host, Mario Lizarraga, and on this podcast, we get real. We connect everyday people with trusted professionals who break down the tough stuff: pensions, tax planning, insurance, and today we're going to talk about pros and cons of wills and trusts. This episode is part of our law enforcement series, and I'm joined by my co-host, Officer Ty, an 18-year veteran of law enforcement here in Phoenix. Our guest today is Cindy Starkey, a powerhouse attorney with 35 years of experience in wills, trusts, and probate law. You can find her at Cynthia Starkey, PLLC, and she's guided thousands of families in tough moments of their lives. Today, we're answering a tough question, though: pros and cons of wills and trusts. And from that moment, I can't talk, folks. So here we're just going to turn it on over to someone who can, and she talks for a living out there, litigator and attorney at law. Here she is. Cindy Starkey. Welcome.
Mario. It's good to be back with you guys again. Hi, Officer Ty. How are you?
Hello. How's it going?
Good. So we talked a little bit about the differences, pros and cons between wills and trusts last episode. One of the primary ones is the expense. You know, the will is much cheaper up front and the trust is more expensive up front. But then in the long run, the will ends up costing you more, but the trust ends up costing you less because of court fees and time and things like that. But the other really important difference that I don't think a lot of people realize is privacy. So a will, when you open a probate and you have a will, or even if there is no will and it's an intestate probate, everything that you file is public record. And during the course of that probate estate, you have to do an inventory. Your personal representative does an inventory and says, these are the assets in the deceased person's estate. They have a house that's worth this general amount of money. They have bank accounts worth this amount of money. They have stock worth this amount of money. And it's all laid out and a public record of what you own. And then later on, that's the initial inventory. Later on, there's more specific information that you provide with like exact detail and how it's going to be distributed. And the other thing that's public record that is really important to know is who's getting the money. You know, your beneficiaries, that's all a public document. Your first filing tells the court everybody who is a beneficiary under the will or anybody who's interested under Arizona law because they have to be notified. So there's a lot of information that people don't realize ends up in the public domain if you have to probate an estate. Now, in comparison, if you have a trust document is completely private. It's never filed with the state or with the court unless it's contested by one of the, beneficiaries or somebody. But usually it's never filed with the state. And in fact, you don't even usually have to give that trust document to a bank to open accounts and things like that. You give them something called a certificate of trust, which just has the bare bones, who's entitled to act on behalf of the trust, who the beneficiaries are, and what the name of the trust is and what the powers of the trustee are. So they don't get to know how much your estate is worth, how many homes you own, what your bank accounts are. They know none of that. And that's all completely private. So I think a lot of people don't really understand that they put so much more of their information out there if they go the will route versus the trust route.
And that's in the first episode we talked about, if you didn't have a will, then it goes to some different kind of probate, but it's similar. Either way, with a will or without a will, it's going to the courts. Once it goes to the courts, it's public information. Is that correct?
That's correct.
So with or without a will, it's going before, and privacy is out the door.
Yep. The only time you're protecting that privacy is if you have a trust.
Most cops want some privacy, so that's a big.
I think most people,
sure they do.
You're operator law enforcement or not, you want. So I want. Now hearing that, I mean, that's a bigger reason why I'd want to I'd want to trust. I mean, there's a lot of reasons I should have one, but that's a big one. Just that I'm private.
Yeah, 100%. Yeah.
That's
Trust Yeah, trusts are also a lot more flexible than a will. Like a will only kicks in when somebody dies, and then you file the will and you probate their estate. But a trust is a living document. I mean, they're called revocable family trusts, well, living wills. They're not living wills, they're trusts. But they're living. It's a living document that can change, and it takes effect immediately. So if you want to, a lot of people, when they pass away, they don't really, if they have a big estate, they don't want to give their kids, even if their kids are grown and, they're 20 years old or 21 years old. If you have $500,000 that your kids can get, you don't want to get them to get $500,000 when they're 18 or 20 years old. So if you have a trust document, you can dictate exactly how that money is passed down. And I always recommend to my clients that at 18, the children get some portion of it, maybe enough to buy a car, to go to college, to start a business, to go to trade school. And then at 30, they get another big chunk because now they might want to buy a house or they might be starting to have kids. So they have additional financial responsibilities. And then maybe when they're 40 years old and they're hopefully, you know, very fiscally responsible, then you could give them that big chunk of money so that you know that they're gonna handle it appropriately. Um, Go ahead.
I'm sorry to ask you a question, but you triggered a thought there. So if someone were to stagger that out, obviously they have to have somebody kind of oversee that money that's left in the account. So who is that person? Where do they go find? What do they have to include in that set of documents there?
Yeah, that person is a trustee, and as soon as you set up a trust, you appoint a trustee, and it's usually yourself and your spouse. And then after you and your spouse are gone, you set up somebody else who's gonna be your successor trustee, and that person is typically, one of your kids or a sibling, but it has to be somebody that's at a different age range. Because if it's a sibling, they may, unless they're younger than you, you might have the same problem with they're not gonna be around. But it could be a family friend, it could be, whatever, but typically it's one of the kids.
If
Or
there's like family that someone trusts to do that, I assume that there's people that they can hire. Do they hire another attorney to oversee that, or are there just professionals out there who do just that?
there are professionals who do just that. There are fiduciaries. Lots of banks will have fiduciaries on. So if you have all of your money at, maybe Chase Bank, and you don't have anybody that you trust in your family to do, to act as trustee, you could appoint them. They take a percentage of the estate, so it's a lot more expensive. But you also, have somebody who's relatively, not biased against, you don't have infighting between, if you have one child that you appoint and the other two you don't, you might have some disagreement.
Can you put in stipulations on the trustee? So let's just say there were two siblings, but I wanted just one particular child to be my trustee. But I want to make sure that that trustee didn't just go rogue within the trust. Can I put stipulations prior to while I'm still here so the trustee can't go rogue?
So the trustee has fiduciary responsibilities under Arizona law. And if the trustee goes outside of that and is taking advantage and maybe using the money for um, their own personal self instead of sharing it with other beneficiaries, that's when you end up in court and you end up having litigation over it, probate litigation. Um, but every trustee has fiduciary responsibilities and they have to act in the best interest of all of the beneficiaries, not just themselves. And there are duties that are outlined in the trust agreement, what they can and cannot do. And so if you know somebody, well, that's really probably one of the most important things about um, when you form your trust is you really have to think about who you're going to appoint. And a lot of people, their knee jerk reaction is, I'm going to appoint my oldest kid. Well, your oldest kid might not be your most financially astute, might not be your most organized, might not be your most trustworthy, maybe have a substance abuse issue or, going through a bad divorce or mental health issues. So you really have to think about who you're going to appoint because they have a lot of responsibility.
We went through this with my mom's side of the family.
They did. So you've experienced this.
Yeah, well, kind of. It was the
Yeah. 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 Long story short, but it was
kind of that. It was one of the siblings thought that they were in charge of everything. Nobody was appointed, so it was kind of like constant fighting between the siblings. It was a mess.
It sounds like there's probably a whole episode within itself right there. We should need to have a conversation. How do you protect yourself from a trustee going rogue? Right?
Yeah. Yeah.
Yeah. You know,
I
'cause-
actually have a case with siblings, and there was no, well, he was not acting under a power of attorney. And he was just, his mom needed some extra help, and he just jumped in there and was handling her accounts and took basically all her money. And now we have a lawsuit. But that's what happens when, he wasn't acting under a power of attorney, so he didn't have those fiduciary duties, and we have to litigate under different law, whether he had undue influence over his mother, whether she's a vulnerable adult or incapacitated. Whole new can of worms, way more expensive. A lot of the estate is getting eaten up by attorney's fees, unfortunately. But that's why if you have documents in place and they're, everything's set out and you've really thought about who you're going to appoint, you know, which of your children gets along the best with everybody, or is there one person who's really gonna, set off the other children? You really have to think about your family dynamics when you decide who you choose, or maybe you don't choose any of your kids and you go with a cousin or an aunt or a family friend or somebody that isn't gonna, be in the middle of things and stir trouble up.
what a mess.
It is a mess.
This is I just can't imagine. So thankful there's people like you out there, Cindy, who want to deal with this mess because this just sounds like a train wreck.
Yeah.
So even more reason why obviously I need to get a trust because I don't
Yeah,
have
but
duking it out. Yeah, over all this big money.
the last thing that I'd probably mention about, what's good about a trust is, over a will is, um, when you have a will and you're ready to close your probate, everybody just gets their money, and I said you can't stagger like you could with a trust, but you also might have children who have substance abuse issues, who are going through a bankruptcy, who, just got in a terrible car accident and maybe has a lawsuit hanging over their head or lawsuit for something else. So if you have, within your trust document, which all my trust documents have a spendthrift provision, then that, keeps all the money in the trust. The trustee cannot distribute money to somebody who's going to one of the beneficiaries who's going through a lot of problems, and that protects them while they resolve their problems, get their substance abuse issues under control, and then when the trustee thinks that they're capable and ready to handle the money, then they can dole it out slowly or they could dole it out altogether. And that's just a provision that even if you have it staggered and you say they get it some at 18, some at 30, some at 40, if there's problems going on, the trustee is aware of it. They can keep control of the money to make sure that it doesn't end up in a creditor's pocket instead of in their kid's pocket where you really want it.
Okay.
So there's a lot of
It was called the spendthrift.
spendthrift provision, because sometimes it's just kids that are terrible with money. So the trustee has complete power to say, no, you're not handling yourself very responsibly. I'm not going to give you your big chunk of money. But they can come to you and say, I have this medical expense. And if the trustee believes them, then they can hand out money, or if they have an educational expense or they're starting a business, the trustee has complete control really to do whatever's in the best interest of that beneficiary within the provisions of the document.
Hmm, never knew that.
Interesting.
Yeah, there's all kinds of crazy things going on. Um, wow. I don't know. I mean, you just kind of you have a lot of things spinning in my head. If you don't, you have more questions pertaining to spendthrift? Because otherwise, I have a question I want to
No.
come back to that I heard you said. So you mentioned about okay, so just because you have a trust, it sounds like I always assume that you could contest like a will. You hear people contesting a will or something. It sounded like that I heard you say that you could also contest a trust. That is that accurate?
That is true. You could contest either of them, and that's why it's really important to put in a no contest provision in your wills and your trusts, and that kind of heads off battles that are not legitimate battles between siblings or, family members who maybe just don't get along and want to fight about everything. So if somebody contests a will or a trust, they can be completely disinherited. So that's a big incentive not to contest a trust or will.
What's
But
the name of that provision?
a no contest provision.
So that in a no contest, if you put that in there and somebody does contest it, that can kick them out of it completely.
Then they could lose everything.
It's
But
Like,
the word being if they have a legitimate, right? So then you have to have a judge determine whether or not it's legitimate.
you're correct. So it under Arizona law, it's if you have probable cause to contest, then the judge will say, okay, you can contest it because I see that there's probable cause. So I'm not going to even if you lose the case, if I can't think of a scenario under my, on the top of my head, but if you think that your sibling did something wrong and mishandled some of the money or didn't give you enough, and there's a legitimate reason why you feel that way, and you bring that to the court, even if you lose, the court could say, "Oh, I could see how you would feel that way, and I'm gonna say that you had probable cause, so I'm not disinheriting you." Conversely, if you just had no reason, you just had bad blood between siblings and you just wanna cause trouble and try and get as much for yourself as you can, then you could go to the court and contest the will, and the judge has to determine whether you had probable cause, and if the court says you didn't have probable cause, you're just being a jerk, then you're disinherited.
Crazy. Yikes. Yeah. And that can be, so you can put that clause in with a will or a trust?
Yep, yep, and it's in all my wills and trusts.
So is that just kind of standard regardless of you go or do not at all? I mean, I assume if you go to an attorney, they're going to recommend that. But I know I've seen like a lot of these third party legal services. We do your will for free. Right. And I've always been kind of suspect of that situation. Like what aren't they paying attention to?
yeah,
Right. Go to Legal Shield or what are these online legal forms?
legal Zoom.
Legal Zoo. And there's like a bunch of them out there. And I've always been leery of like, well, so what I knew, why do we need an attorney?
So yeah, so that would that be a question then? If I were to go on right now and go on like LegalZoom, would they have stuff like that in there? I'm like, I don't even know. Does like LegalZoom like explain to that to you? Like if I'm gonna fill out this trust paperwork, and if you put this in there, I would assume they probably don't explain it that well, or do I don't know. I've never went on there, so I have no idea.
I mean, all these little bombshells that are just in within this situation. I mean, it sounds like more reason why save the. I mean, it can't what be $500. I mean, I mean, not to pin you down, but like, what's the average cost of a will opposed to a trust? So
What is the average cost?
yeah, average cost. What would you say? Like,
Well,
rate?
it varies so tremendously depending on what the attorney bills out at. I like to do mine as a flat fee because I don't want my client not to ask me questions. I don't want them to worry about picking up the phone and think that, oh gosh, every minute because we bill in 6-minute increments.
Yeah.
So if I'm billing by the hour, every 6 minutes I talk to you, another charge is tacked on. I'd prefer not to have that so that, I just quote a flat fee and it is what it is. And no matter how much time I have to talk to you or your spouse or your kids if they have questions, no matter how many times we have to go back and forth with the documents or questions you have, it's all included in the flat fee.
Is that standard, or is that something that you do? Is that pretty standard amongst your your side of the profession?
Yeah, I'm sure if you'd say it was 50-50 or not. But I think a lot of people offer a flat fee because I think a lot of clients don't want to not know how much it's going to cost.
Yeah.
You know, um, if you have a I don't do it sometimes if you have a very complex estate. And I have some people that want to leave money to their grandchildren some of them get this amount of money and some get this amount of money, but if they're doing this then they don't get anything. And if I want to leave something to my brother also, if it's really complicated, most people the scenario is husband and wife, you leave it to your spouse, everything to your spouse. When that spouse goes, it's divided to the kids. That's when a legal Zoom or a very simple will wouldn't be terrible because it's pretty basic. And in fact, I'm putting together some forms for my website where people can go in the middle of the night if they wanted to answer a questionnaire and it will populate a will or trust for them and they can print those and sign them in front of a notary and it'll be a done deal and they'll pay me a flat fee. And then if they want to ask me questions, if as they're doing the documents, they're like, oh, I really wonder about this. I wonder, then they can hire me at an hourly rate or, at a different flat fee rate so that they can get their questions answered. Because I think a lot of people don't realize how complicated they are. There's a lot of questions and there's a lot of, it's very individualized for, especially when you have blended families, then things get very crazy and people, want to treat their kids and their spouse's kids differently.
Families.
Yeah. So it can be very complicated. And then you're probably not going to get a flat fee, um, an agreement. You're going to pay by the hour because you want it done bespoke perfectly to fit your individual needs.
Which makes total sense. So, I mean, and if you're going to do it, you want it done right.
Yeah.
I mean, if you're going through that trouble of doing it, so even at a basic level, start with the will and likely talk to a state planning attorney like yourself I would like to think that everybody does things correctly, but I know we all know that's not the case.
Actually, I do just made me remember that I had a client who I did all of his family's trust documents, the mom and dad, and then all the siblings and their wives. And as they grew up, and got married, I did all of their trust documents also. And I got a call one day that there was something wrong with the power of attorney and the court was rejecting it for some really reason. And I panicked thinking that there's something wrong with my document because I'm like, so I went back and looked and I'm like, oh, that's not even my document. So where did you get this from? And he goes, oh yeah, I remember now. I went on Zoom and I did a Zoom and it wasn't notarized or something like that. So it was completely ineffective under Arizona law. So I would hope that a Zoom or one of those legal, like what did you say, Mario? Who was that firm that does something?
There's a bunch. Something, yeah, legal shit. There's a bunch of them out there. See,
You'd hope they do it right, but you don't know. If you don't have an attorney overseeing it, you're not 100, you don't ever know.
and the good argument there is you also, at that point in time, you don't have any legal recourse, right? Right. And if you do something and it's in you fail to do something incorrectly, I have legal recourse against you, correct?
Yeah.
Right. So even more reason why to, spit the money. That way you can make sure you're protected.
Yep.
Right. So, I mean, not that we want to sue our attorney, but at the same time, the pressure is on.
Did you got that option?
Well, cool. Well, again, this is I don't know. You just keep opening more and more doors. So, of topics of conversation, because this is a lot broader subject than I really thought.
It's definitely more to it.
So, but this is a good jump off point, I think. And Cindy, thank you again for jumping on, and another one in the bucket here. And so, thanks for jumping on. You're up in Washington currently, right?
Currently. Still practicing law in Arizona, though.
Right, right. So, thanks for jumping on via Zoom. We appreciate that, and
Thank you for having me.
look forward to having you in the studio here and jumping on. So,
Yeah.
you know, you can jump, listen to Yahoo's lap before the show, not just have to hear this. That's what we're here for. So,
Well, I appreciate
see you in Washington.
it. Take care, guys.
Thank you. Bye.